docket. Case number 111345, State of Kansas v. Brown.
May it please the court, Peter Meharry for Mr. Brown. If I could have 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. This case comes before the court after Mr. Brown's conviction pursuant to a jury trial of multiple offenses, including felony murder, as well as criminal possession of a firearm, criminal discharge of a firearm, attempted egg robbery, and egg burglary. He was sentenced to life without parole for 20 years plus 60 months. In this case, we have raised 3 issues, and I'd like to start with the first one, which is somewhat interrelated with the second one as well, and that deals with the sufficiency of the evidence as it relates to the attempted egg robbery conviction. In this case, the state's theory was that my client, along with a companion, set up a drug deal. However, their intent was not to actually buy drugs, but to steal them. Eventually, as it came about, Mr. Rohn, the person who they were going to attempt to steal the drugs from, was found shot. However, they never did find the drugs. At trial, the state presented multiple witnesses, including a jailhouse informant, who said that my client confessed to him, but did not say whether or not my client actually got the drugs. Likewise, the police officers testified that they had no idea what happened to the drugs, and the state admitted in closing arguments that they could not say what happened to the drugs. It's our position that with that type of testimony, there is insufficient evidence to support the conviction for attempted egg robbery. As this court well knows, that attempt requires 3 elements. One being an overt act toward the preparation or completion of that crime. Second, the intent to complete the underlying crime. And third is the failure to do so, the failure to complete the underlying crime. And in this case, we believe that testimony is that it's basically speculation as to whether or not my client completed or failed to complete the attempted robbery. They simply don't know. The testimony at trial was they don't know what happened to the drugs. They do not know if my client got the drugs, if he actually robbed the victim in this case, or did not. It's our position that without more, the jury is basically speculating or guessing as to whether or not that was a completed crime or just an attempt. Attempt requires, as an essential element, evidence to show that there was a failure to complete the crime. And in this case, we do not believe that there was that evidence.
Just so I'm clear, Mr. Meharry, the standalone underlying crime was an attempt only. Charged as an attempt, or was it a conviction of the lesser included of a completed crime?
It was charged as an attempted aggravated robbery.
Okay.
The failure to prove that crime also relates to the fact that it was used as one of 2 alternative means to commit the felony murder. So we don't believe that there is, if you're using attempted egg robbery to support your felony murder, you have sufficient evidence to support that charge as well. I don't want to repeat what I've just said, but based on the insufficient evidence.
But the wording of the felony murder is broader than just an attempt or a completed crime, isn't it? It's a broader segment of time and a broader array of activities that could support the felony murder.
I believe when you look at the felony murder statute, it requires that you prove either that it was done during the commission of, the attempt to commit a inherently dangerous felony, or the fleeing or escaping from.
Right.
I still think in this case there is no evidence or insufficient evidence to prove a completed crime, as well as insufficient evidence to prove that he failed. We simply don't know. So in that regard, I still think it is insufficient to support that felony murder charge.
But to go back, excuse me, go ahead.
Does the jury have to agree on which of those, whether it's in the attempt to commit, the failure to complete, or do we have to have jury unanimity on that?
I believe that's considered alternative means by this court, that it just has to be essentially sufficient evidence for one or the other. But it's our contention that there is insufficient evidence for both of those alternative means.
Why is there not circumstantial evidence of the completion of the crime? If you're basing your theory that we don't know what happened to the drugs, but we have the girlfriend overhearing the phone call that that Roan was going to a location for the sale of drugs, we have the prison mate or jailmate statements that was the purpose. Why is there not circumstantial evidence?
I don't think it is enough as far as that type of testimony to rise to something that the jury can base its decision on beyond speculation. I think it is just, we don't know.
What's the line between circumstantial evidence and speculation for you?
I don't know that I can draw that line for you in nice red ink, but I think in this case we haven't gotten to that point where you have enough evidence where you could say, okay, the jury could conclude from this evidence that there was either a completed crime or no, he failed.
Let's review what we have. We don't really have much dispute about that. We have no dispute, in fact, about the girlfriend's testimony that he was going to sell drugs.
That was her testimony, Your Honor.
So presumably he's going to sell them. He's got them. No dispute about that. Then they weren't found on him or in the car, right?
That was testimony, yes.
And he was found, and the car was found within minutes of people hearing shots.
Correct.
So it's not like he's wandering around and someone else could have taken the drugs off of him in the interim. That would be speculation, I think.
I think that could be speculation, but by the same token, I think it's similarly speculation to say, okay, my client must have taken them. Because you just don't know what happened to those drugs. And without more, we don't believe that there's a sufficient basis.
We often don't know something, certainly, and we say that it's circumstantially supported, don't we?
There are certainly many cases out there where you base a conviction on circumstantial evidence. We just don't feel that the evidence here, the circumstantial evidence here, is sufficient.
Let's go back to the first question. You, on the difference between your two arguments, with regard to the actual attempted ag robbery, you're saying that all three elements have to be present, including the failure to complete. But all three elements do not have to be present for felony murder, do they? If he just did the overt act and the murder occurred before they completed, that's still felony murder, is it not?
I still think in that situation, though, you have to prove an attempt. And we have statutorily defined what an attempt is.
Well, why do we have to prove the attempt? It's in the commission of. It doesn't have to be completed.
But again, I guess go back to commission of or attempt to commit an inherently dangerous felony. And when we talk about an attempt, we have a statutorily defined definition of what that attempt is. And that requires...
Why doesn't it fit in the commission of here?
I'm sorry?
Why doesn't it fit in the commission of? If he did an overt act and towards the ag robbery and killed Mr. Roan before either the crime or the attempt was completed, why is that not in the commission of? And we have cases that say you don't have to have evidence or all the elements of the other underlying felony. You agree with that?
That is certainly the case, Lobby, that this court has. Again, I guess when you're looking at the felony murder, it's the commission or attempt to commit aggravated robbery.
You're reading commission to mean completed crime. That's the
I think that is the distinction, because
I think what you're arguing is there's no distinction. That in the commission of means you have to have a completed crime. That's the way you're reading the felony murder statute. In order to make your issue 1 contiguous with your issue 2, you have to say that in the commission of it equals a completed crime.
And I think when you look at the felony murder statute, it gives the alternatives: commission of, attempt to, or fleeing. If commission of is an attempt, that would seem to be duplicative of the following language about attempt. So I guess that's, when you have felony murder say these are the options you have, they give you 3 options. It doesn't make sense to me to read that as option 1 and option 2 are exactly the same. If there are no other questions, I would like to touch on the final issue, and that does deal with the sentencing. As I indicated before, he was sentenced to life without the possibility of parole for 20 years, plus an additional 60 months incarceration based upon the base offense or the primary offense of aggravated burglary. It's our position that under KSA 6819, that is an illegal sentence. That statute provides the total prison sentence imposed in a case involving multiple convictions arising from multiple counts within an information complaint or indictment cannot exceed twice the base sentence. The base sentence in this case was the egg burglary. That was a sentence of 60 months. It's our position that when you are following that statute in a multiple conviction case, your total sentence per the statute can only be twice that, which in this case would be 120 months. Obviously,
So what happens to the off-grid crime?
Your Honor, I
I
think
mean, doesn't this statute specifically exclude off-grid crimes from that calculation? I mean, otherwise, it just you can't sentence for what the off-grid crime contemplates, which is a life sentence, parole or eligibility not for 20 years in this instance. Doesn't that just render that a sentence that can't be imposed if we follow your logic?
I guess I look at the statute and it does not exclude off-grid crimes from this provision. And I think certainly the legislature could have put that in, saying that this section applies only to on-grid crimes, but they did not. And I think when you look at the plain language of the statute, it talks about multiple conviction cases, which is what we have here. And it specifically says twice the base sentence. It doesn't say twice the base sentence excluding life sentences. It doesn't say twice the base sentence excluding off-grid crimes. So I think when you look at the statute itself, it imposes those limitations in these type of cases. And in this case, we believe the district court, in sentencing the way it did, went against the provisions of that statute.
But before you get there, you have to say that a, quote, multiple conviction case, end quote, includes where one of the convictions is off-grid.
I guess I don't see, the statute says the total prison sentence imposed in a case involving multiple convictions, which we have here, arising from multiple counts within an information complaint or indictment cannot exceed to twice the base sentence. That's the language of the statute. We have a multiple conviction case here. Those convictions came all part of one information or one complaint, and we believe that that statute controls and limits the total sentence you can impose in this case. I think to go beyond that and include language that excludes off-grid goes against the plain language of the statute. For that reason, we believe that the district court did err in sentencing Mr. Brown to the sentence that it did as far as life plus 60 months. If there are no other questions, we would ask that this court reverse for the reasons stated in our brief.
Any more questions? Thank you, counsel.
Thank you.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. Beginning with issue 1, the attempted aggravated robbery. Of course, I'd start by reminding this court of the standard of review, that the evidence is to be viewed at this stage in the light most favorable to the state, and that you should review the evidence and all inferences therefrom in a light most favorable to the state. The argument...
Maloney,
Go ahead.
what's your circumstantial evidence of failure to complete the crime?
The circumstantial evidence of failure to complete the crime is the fact that the drugs were never found on the defendant or in the residence that he was arrested. Clearly, this would have been an easier case for us at the district court level had we had affirmative evidence that the drugs were found on the victim or in his vehicle or somewhere else. other than with the defendant.
What about the co-defendant? Was there any evidence about the co-defendant?
That is a question that I considered as I was preparing for the argument, and I don't recall there being specific evidence one way or the other in this trial as to whether they searched him when he was arrested and found any drugs. I think that by implication, the answer would be no, because the officers did testify that they did not know what happened to the drugs, that they never found them.
And what was the lag time on both of them between the time the shooting happened and the time of arrest?
This defendant was arrested, I believe, the morning after the crime at his mother's house. So with respect to the defendant, it would just be a matter of presumably hours. 8 to 10 hours, I would guess, would maybe be an estimate based on when he was arrested. I'm not sure that I recall exactly when the co-defendant was taken into custody.
Thank you.
Our position is that essentially what the defendant has argued in his brief, and again here today, is that since we don't know specifically what happened to the drugs, that the jury just had to guess, and that in the defendant's view, there was no evidence of either a completed crime or an attempted crime because we don't know. My response to that would be that essentially what the defendant is arguing is that this defendant should get a complete free pass on this crime. That unless the state can affirmatively prove where the drugs ended up, that we're not able to sustain a conviction for either attempt or completed crime. As I pointed out in the brief, I have little doubt that if the state had instead chosen to charge and attempt to prove the completed crime of aggravated robbery, the defense would certainly be arguing that we failed to show that he did in fact take control of the drugs at any point. Because we didn't have evidence that he did, I think that the state made the reasonable, correct charging decision in charging it as an attempt. As Your Honors pointed out, what we have here is there was undisputed evidence from the victim's girlfriend that he was going to sell the drugs to the defendant. The defendant's statement to his fellow inmate indicated that the defendant, of course, all along was not planning on purchasing these drugs. He was planning on stealing them. And again, the evidence, we simply don't know what happened. I would submit that obviously there's all sorts of things that could have happened to him. The drugs, for all we know, the victim, after he was able to drive away from the crime scene, he could have thrown him out the window on the way to the Quick Trip. Perhaps somebody at the Quick Trip did take the drugs from him. The facts show that what happened was...
But it's not the state's burden to show possible scenarios, is it? I mean, it's the state's burden to prove all the elements, and one of the elements of attempt is fails in the perpetration thereof, or is prevented or intercepted in executing the crime.
Right.
And so that's an element of the crime, and what I'm not hearing is what is the circumstantial evidence of a failure when the victim didn't have the drugs and we knew the victim went there with the drugs from his girlfriend. That's circumstantial evidence that someone took them from him, and presumably the defendant, but how is it circumstantial evidence of a failure to complete?
Well, I think you have to look at it in its entirety, what the defendant told this fellow inmate, which was that they went there to steal the drugs, that he got in the vehicle with the victim, but that the shooting occurred because the victim hesitated to turn over the drugs. So I think that when you combine that with the fact that the drugs were not found on the defendant, that would be an indication that the defendant did not ever gain possession. And of course, the case law tells us that for possession, for a completed taking, it has to be complete, absolute possession and control. And here we do have affirmative evidence indicating that the victim hesitated to turn over the drugs, and that's why he ended up getting shot. Again, I certainly don't dispute the fact that this case would have been much more cut and dry if the drugs had been found in the victim's pocket or in the victim's vehicle. That simply wasn't the case, and I think given the circumstances here, there is a reasonable inference that can be drawn from the fact that the drugs were not found on the defendant. Again, somebody could have swiped these drugs from the victim while he was in the parking lot at the Quick Trip before a customer went in and told the clerk that he was there, and that's when the off-duty police officer went and found him, and when he was then treated by EMS personnel. So I think, again, the arguments that the defendant is making are very valid arguments to make in front of a jury and to try and convince them that we don't know what happened to this, we don't know that there was a failure to commit it, and therefore you should not be convinced beyond a reasonable doubt that it was a failure to commit the crime. However, the jury is the one that gets to make that decision, and on appeal now, we're not looking to substitute our view for whether we or anybody in this courtroom would have convicted on that charge. It's whether, in the light most favorable to the state, and looking at the reasonable inferences, if a jury could have found that. And our position is that, based on the totality of the evidence, the defendant is not entitled to relief.
So the original answer to my question, the answer to my original question and to my colleague's repeat of the question is, they were doing this kind of, you show me the money, you show me the drugs thing in the car. And because there was some hesitation on the part of the victim to hand over the drugs, that's when the defendant leaps out of the car, and then the two shooters start firing. And then ultimately the defendant is arrested and the drugs are not either on his person or in his house. That's your circumstantial evidence of failure.
Yes, and again, I would emphasize that portion of it in which the defendant himself said that essentially the reason that the victim ended up getting shot is because he did end up resisting.
And I have a clarifying question to add to that.
Sure.
Was there ever any evidence that that drugs were even present at all?
I don't know that there was, in the sense of, I don't think that the victim's girlfriend ever specifically testified that she saw him physically.
As I read it, it appears possible from the evidence, at least, that there may not have been drugs present at all.
I understand where you're coming from in asking that question. I guess I have a hard time understanding how exactly in that scenario the victim, why he ever would have been meeting up with these two men in the first place, because there's certainly no indication that he was armed.
Well, that may lead to subsequent questions. I understand. I'm just trying to understand what evidence was presented. And as I understand it, no one said that they saw drugs in the car ever. I mean, that's where this hesitancy to hand over the drugs comes in. And then there was the shooting.
Yeah, I think that my best answer to that would simply be the girlfriend's testimony, that she knew that meant that, based on what she heard on the phone, she knew that he was going to sell drugs based on his prior history doing that. So I think that is essentially the evidence that we have. And I think it's a little hard to envision a scenario in which he wouldn't have had the drugs there, because I don't know exactly how he would.
This is why it's relevant to me. From your perspective, is it possible for someone to be convicted of aggravated robbery when they of attempted aggravated robbery when they attempt to steal something from someone who doesn't possess it?
I would argue, because you'd still be looking at the defendant's conduct and his intent and whether he...
And the failure could come from a failure of the actual object to be present, right?
Correct.
Right.
Correct.
So, and again, that would strike me as circumstantial evidence that supports the failure without having to locate the drugs, because one way the crime can fail is for the drugs never to have been there in the first place.
Exactly. Yeah, the case law and the statute does not say that the failure has to be because of anything that doesn't have to be the defendant who himself fails to do something because of his own inaction, or, as Your Honor pointed out, it could be something that was impossible to do because of the victim in this situation. So, again, I realize that the facts are not exactly what we would consider typical, but I do think that there is evidence from which the jury could have convicted him, as it did do. As to issue 2, obviously the underlying argument relies largely on the same premise that issue 1 does, so I won't repeat my comments. I would note, however, that the difference is that the defendant has, in this particular count is that, as the case law tells us, the state is never required to prove, or indeed I don't think even charge, the underlying felony in order to sustain a felony murder conviction. Beyond that, as your honors discussed with opposing counsel, is the fact that the case law talks about that the killing simply has to be, you have to be simultaneously engaging in an inherently dangerous felony, and that element can be established through proof that the killing occurred while committing or attempting to commit or fleeing from the inherently dangerous felony. So it's not something where those are not alternative means. The case law is clear on that. And so given the nature of the evidence here, our position is that the underlying argument fails. I would note that in the brief, the defendant twice concedes that even if he were to be successful on this particular argument, that the remedy would simply be to remand and have the district court impose sentence on the alternative felony murder count, which used criminal discharge of a firearm as the underlying felony. So even if this court were to agree with the legal argument made by the defendant, he would not be entitled to any relief or to have his felony murder conviction overturned. He would simply be resentenced on the other alternative count that was charged there. Turning briefly to issue 3, I really don't have anything to add to what our Court of Appeals said in Groton with respect to this issue. I think that's a well-reasoned opinion and is consistent with A, the language of the statute, and B, the desire to avoid unreasonable or absurd results in interpreting statutes. And of course, I just remind this court that you need to look at the statute as a whole and not just a particular subsection or clause in a subsection. Again, I think the analysis in Groton was very well reasoned. I did, after filing the brief, when this court released its opinion in McClellan, I filed a 609 on that. I acknowledge that in McClellan, it was not raised specifically as this particular issue, but nevertheless, I find the rationale and the opinion in McClellan does carry some significant weight, I would argue, and it just further supports our position and the position that the Court of Appeals took in Groton.
And is that position essentially that that you concede the plain language, but simply say that would be absurd, and we just can't apply that plain language because it's just absurd? I mean, is that the sum and substance of the state's position?
I don't know that I would say that we concede the plain language, because I think that when you look at the statute as a whole, speaking of 2168-19 and subsection B in particular, when you look at B2, that subsection tells us that that an off-grid crime shall not be used as the primary crime in determining the base sentence when imposing multiple sentences. And so I would argue that subsection of the statute
But that says you can't use the off-grid for the primary crime. But how does that impact the defendant's argument that the plain language of the double rule is you get your base sentence and it's just math. You just multiply it by 2 and you're capped at that. And I understand the state's position as to why that's absurd.
Sure.
But what I'm trying to get at is there anything else that would enable this court to get around what we've said repeatedly, our commitment to enforcing the plain language of the statute? Because the language of the double rule is pretty plain, isn't it?
I think that if by plain language, if the only statutory section or subsection that existed were B4, then yes, I would have to agree that the plain language of that particular subsection would seem to favor the defendant's argument, and then the state would be relying solely on avoiding unreasonable results. I think when you read B4 and B2 together, our position is that B2 kind of explains why B4 doesn't mean exactly what the defendant is suggesting that it means.
Well, we have found ambiguity in the relationship between 2 different statutes, have we not? I think it was the Horn case where we said the language of this particular statute, or I think it was the attempt, was not ambiguous, but when you can look at it in relation to another statute, that renders it ambiguous. And I think that's what Groton was trying to say, that you have the sentencing statute with regard to off-grid that specifies certain life sentences.
Right.
And that there's your ambiguity when you try to construe the double provision in relation to the off-grid.
Correct. And that's why I think essentially what the Groton court said then is that reading these different provisions and trying to synthesize them and avoid unreasonable results is that the indication is then that the double rule simply does not apply to the non-grid portion, and it only comes into play once that off-grid sentence has been completed. And then at that point, when you're looking at the multiple counts remaining on the grid crimes, that's when the double rule comes into play.
Well, the point is, we have to get to an ambiguity to get around the clear language, don't we? I mean, with the way we've been construing statutes.
I think that's probably a fair comment, Your Honor. Yes, I would agree with that. If there are no further questions, we would submit the case on the arguments raised in the brief and respectfully request that the defendant's convictions and sentence be affirmed.
Any more questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
Unless there are additional questions, I would waive rebuttal, Your Honor.
Well, what about the aspect that there are specific statutes dealing with off-grid that say there are life sentence, and so in order to construe an act in pari materia, so how can you construe those two and still give effect to the plain language of the double rule?
I think the plain language of the double rule would carry the day. And I don't think you can look at that language and say that it is ambiguous. It clearly states that in a multiple conviction case, you can only go twice the base sentence. And I would think even when you look at it, whether or not that would shorten an off-grid sentence considerably. You could make the same argument if you have multiple felony convictions for severity level 1 crimes. You could have, those be shortened because they are capped at twice the base sentence. So I think its effect on off-grid crimes could be seen as similarly affecting other on-grid crimes. And again, going back, not to sound like a broken record, but going back to the language of that statute, it just says, in a multiple conviction case, the sentence cannot exceed twice the base sentence. And I think that language is clear, and I think that is what this court should look at first and foremost. And when it looks at it, it's clear and there's no ambiguity, and the court stops there. For that reason, we would again ask...
Counsel, what does that leave us with in this case then, in terms of your client's sentence?
The base sentence in this case was the egg burglary, which was a 60-month sentence, and the 2 times the base sentence would be a 120-month sentence.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.